Welcome everyone. Welcome to the new session. In this session, we are going to learn about articles of association. Yes. Articles of association. So, articles of association is another document which is to be produced along with the memorandum for the registration of your company. So, section 5 subclause 1 of the Companies Act 2013 says that the um, articles of association of a company shall contain regulations. Contain, so it contains regulations for management, regulations for management of the company. Okay, so so that is what exactly articles of association. So articles of association, according to section 5(1) of Companies Act, says that articles of association should contain regulations. What are the regulations? And do you know that articles of association is an internal document? Articles of association, AOA, is an internal document which shall not be given to outsiders. Okay, it is an internal document. Understood? Article of association is definitely an internal document. All right. So, so by section 5(6) of the Act, 5(6), one second. So, section 5(6) of the Act defines, the articles of a company shall be in respective forms specified in table F, G, H, I, and J. So, 5, section 5, 6 explains about uh, articles of association of a company shall be in respective forms. So, what are the forms? F, G, H, I, and J forms. Okay, in Schedule 1. Okay, so in memorandum of association is like in Schedule 1 forms A, B, C, D, E. Okay, these are the forms. So table F to J are model of articles of association of different kinds of company. So in which category you come or your company fall into, you have to select the forms as per the need or demand, uh, or as per the parameters of the company that which you are going to register. So haven't hello, yes, I'm not presenting. Oh my god. So I will start from. I will resume the presentation because you will get the recording. Okay. So should I start from first? All right. So, welcome back, everyone. In this session, we are going to learn about articles of association. Here, articles of association is another document which is to be, you know, compile and produce along with the memorandum of association of a company. Section 5.1 defines what? Article of association, which contains regulation for the management of the company, and articles of association is an internal document only. It is not an external document, and it cannot be asked by, you know, the shareholders or anyone. So they cannot ask to see, or they cannot request to the company, or the you know directors of the company, or whatever it is, who can be, issue the copy of articles of association. They cannot ask those things to those people who are in charge of giving public information. So article of association is not a public document, but memorandum of association is a public document. Understood? So article of association, according to section 5.6, articles of association um, has different forms in schedule 1. As per schedule 1, the forms names are again form F, form G, H, I and J. So about memorandum of association also had form as per the, as per the company needs, wants and company demands or parameters. We have to select a form A to E in memorandum of association, same as like table F to J are model articles of association of different kinds of companies, that different kinds of company that those people can select. So have an example. Table F or form F is the form of article of association that is applicable to a company limited by shares. Okay, to a company limited by shares. So table G. So G is the article or form of article of association that is applicable to a company limited by guarantee having a share capital. So company limited by guarantee plus share capital, having share capital. So those company have to use form G. Okay, next table H. So those who are using table H form of article of association, which is applicable to company limited by guaranteeing and don't have a share capital, only company limited by guarantee. All right, guarantee. Next is table I is for article form which is used by articles of association or a company's article of association is applicable to an unlimited company and having a share capital. So for unlimited company, table J is the form of article of association that is applicable to an unlimited company and not having a share capital. Unlimited company and don't have a share capital. So these are the requisites of articles of association. Different forms are for different purpose, and different forms are for the demand of a different kinds of a company that you wish to register. Okay, so so next is section 5.7. Hello. Good afternoon. ഞാൻ കുറച്ച് കഴിഞ്ഞ് വിളിക്കാമോ? So 5.7 of section 5.7 defines the act as like a company may adopt all or any of the regulation contained in the model articles applicable to such company. So articles of association and the forms of articles of association should be adopt as per the need and type of the company. Okay, so the article of association should be printed and divided into paragraphs and consecutively numbered. So it should be article of association, it should be like a, it should be printed format. Okay, it should be in printed format. Then it should be divided into paragraphs. Okay, divided into paragraphs. And consequently number. Okay, all right. So it must be signed by subscribers to the memorandum, and the signature are to be attested by a witness. So the who all are subscribed to the memorandum should also have to sign in the article of association. Okay, so those who have signed or signed or subscribed, one second, subscribed, that is the right word. Should subscribed MOA should sign article of association. Okay, so that is also indeed needed. So when we talk about article of association, an article of association shall also contain provisions for certain things, like provisions of explaining about certain things, like one second, share capital. So it has to explain about a share capital, where memorandum of association about explains about the name clause, object clause, location clause, right? Then what else? Subscriber clause. So those things have explained by memorandum of association. On the other side, articles of association explains about a share capital. And variation rights. That means equity shareholders have a different right, and preference shareholders have different rights. So those everything in crystal clear format should be written in articles of association. Then lien on shares. So what do you mean by lien on shares? So it is lien or lend on shares. Okay, so hope you know about the different types of shares. So earnings from the share, and shareholder have the full right of possession of the shares. That is called as lien on shares. So lien on shares is what exactly? A right to keep possession of a property. Okay, possession of shares or whatever, possession of property. Uh, so this is called as a len on shares. So when we talk about shares, there are different kinds of shares that also should be mentioned in articles of association. So next is calls on. One second. One second. Kevin, do you have any complaints, anything from anyone? Those who have not entered into the class, anyone has given any complaints? All right, so go ahead. Fine. So one second, one second. So the third one is calls on shares. So calls on shares. Okay. Calls on shares. So actually, what exactly calls on shares? So the public company can, have a opportunity or option to, offer the invitation for buying the shares and debentures. Here it is called as a calls on shares. So I'm not talking about debentures. So the public company can invite people for subscribe the shares. So through by what way? Through stock exchange, through other websites, etc. So next is, so what are the ways that they choose for calls on shares? That also uh, the company has to mention in article of association. Next is the process of transfer of shares. So is there any problem uh, with the public company or private company, whatever it is, for the transfer of shares? Okay, so that should be mentioned. And the fifth one is transmission of shares. So there is a provision called transmission of shares. So transfer of shares can be done through um, you know stakeholders, or sorry, the shareholders can done through different means, like through brokers, or through, directly they can uh, transfer the shares ownership to some other person. So there is a website called moneycontrol.com. So hope you know about those things. So through moneycontrol.com we can have a gmat account, or you can you can take a a demat account through geojit, or through bank SBI, and you can sell and you can buy shares. Okay, that is called as a transfer of shares. What do you mean by transmission of shares? So transmission of shares is a process by operation of law, where under the shares are registered in a company in the name of a deceased person or an insolvent person, are registered in the name of his legal heirs. So it is called as a transmission. If X has 50 shares of MRF and X has died, okay, who will get the rights of that share? Definitely his lineal descendant will get the right of the share. So that is called as a transmission of shares. It will transmit to the lineal descendant. Okay, lineal descendant of X. That is called as a transmission of shares. Transfer of shares is selling or buying shares from one party to another party, is called as transfer of shares. Next is sixth one is forfeiture of shares. So what do you mean by forfeiture of shares? Forfeiture of share is like a you can surrender or sorry yeah, as per the uh, direction of the company, you have to surrender the shares to the company itself. Is called as a forfeiture of shares. So the procedure of forfeiture of shares, when a company can forfeit the shares. Okay. So next one is alteration of capital. So what is this? Actually, I'm talking about the particulars in articles of association. Okay. Particulars in article of association. So alteration of a capital. So there have an example. A company start with 5 lakh capital, and so the company wanted to alter the capital. So have an example. They wanted to expand their manufacturing firm or expand their retail outlets. Definitely capital is indeed needed. So what are the procedures, what are the ways that they find out capital? So what happens if the capital increases, the you know the qualification shares also have to increase, and the director should also buy the qualification shares. All right. So next is yeah, alteration of a capital, then capitalization of profits. Capitalization of profits. So what is capitalization of profit? So how profit can be, some portion of the profit should be invested in the company. Have an example. I have a three um, partners. Consider the total profit is 1000 rupees, and what exactly I have to do is like I have to divide the total profit into 3. Okay. And one portion I have to give it to the company for maintaining company's day to day activities, capital and all. So the that is called as a capitalization of a profit. Next is buyback of shares. Buyback of shares and forfeiture of shares are different. Okay. Forfeiting of shares is, you we have to compulsory, the company is demanding the shareholders to give back the shares. It's called as a forfeiture of shares. Buyback of shares, if I want to, I don't want to sell my shares to out of I mean, like the company or some other person. I just want to give it back to the company itself. If the company is okay with that, so there are some procedures. This company will buy that. So those procedures will be mentioned in the article of association. So ninth one is a buyback of shares. Okay, the 10th one is general meetings. General meetings. So there are different kinds of meeting that we will learn. Executive general meeting, extraordinary meeting, general meeting. So different meetings we'll learn. So general meetings are the meeting which is then yeah, which is like we have to call all the shareholders and all the members of the company within certain stipulated time from the date of registration. Next is proceeding at what are the different proceedings? what are the things going to happen, or what are the protocols, or what are the invitation proceedings at general meeting. Okay, I mean quorum for the meeting. So have an example, 2 by third majority is the quorum. Have an example, 10 shareholders plus 5 members of the company is equal to 15. So minimum number of people should be needed for holding a general body meeting. So that is 2 by third majority. What is the half of 15? Half of 15 is 7.5, right? Okay, so might be the quorum might be 9 or 8. That is 2 by third majority. 2 by third majority. Most probably 9. Consider it as 9. So everything, some company need 10. Consider. Consider. So imagine. So it is the discretion of the company to decide which is the minimum number of. Otherwise, if you call general body meeting, okay, and no one has came for general body meeting, and I decide only me as a member, I was I was the only one who presented at the general body meeting, and this is my company. I started this company, and I decide everything, and it is a autonomous. Sorry, it is like what exactly autocratic kind of decision making. So that we learn about the quorum of the meeting, that is 2 by third majority is needed for holding a meeting. Next is the adjournment of meeting. What are the procedures of adjourning of a meeting? Next is the voting rights of members. Okay. Next is board of directors. Explain about the board of directors. Then next one is they have to, the article of association should be mentioned about all the details of a full description of a board of directors. That is their name, their age, their father's name, their mother's name, their residence address, okay, their qualification shares, everything. Then proceedings. What are the proceedings? At or proceedings of the board of directors. So what are the different proceedings? So everything should be needed. So in the board of directors, who should be there, the hierarchy, how to select the successor, the predecessor, everything. Next is explain about a CEO, their name, CFO, chief financial officers, COs, chief operating officer, CMO, chief marketing officer, etc. And next is 17, seal of the company. Seal is not mandatory, but if you have seal, that should be also mentioned. You have to give the specimen of the seal. Okay. Next is dividends and reserves. Next is accounts. Next is winding up. Winding up. So those things have to be mentioned. All those things have to be mentioned in article of association. So article of association should have all the details of what all the details of the share capital, the possession right, the calls on share procedures, transfer of shares, transmission of shares, forfeiture of shares, alteration of capital, and the capitalization of profits, buyback of shares, general meetings, proceedings at general meeting, adjourning of meeting procedure, voting rights of all members, then board of directors, proceedings at a board of directors, selection of a CEO, their names, their details, then seal of company, dividends and reserves. So dividends means shares to the shareholders. Then accounts, then winding up of a company. So all these details will be there in articles of association. All right. So there is a case called Madhrubhumi Printing and Publishing. Madhrubhumi Printing and Publishing. One second. Mathrubhumi Printing and Publishing Company versus Vardhavamar. Vardhavamar. All right. So Vardhamamar Publishing Private Limited. Okay, Publishing Limited. So here the Kerala High Court held that the power conferred on the company under section 31 to alter articles of association by special resolution should not be abused by the majority of shareholders in order to oppress the minority. So the alteration must not sanction anything which is illegal. So you can do alteration, but you cannot doing the alternation with a view of suppressing the right of all the shareholders. So in such cases, you cannot alter articles of association. If you are a bona fide you know person or bona fide group of people who gives application for alteration of articles of association in a bona fide manner, then the registrar of companies will give approval for your amendment in articles of association. Otherwise, the articles of association, the alteration must not sanction anything which is illegal. So the alteration must be made bona fide for the benefit of the company. For the benefit of the company, it shall not be for the ഹലോ ഇല്ല ഞാൻ ഫ്രീ ആയിട്ടില്ല, ഞാൻ ക്ലാസ് അല്ല, ഞാൻ ഒരു കുറച്ച് കഴിഞ്ഞ് വിളിക്കാവോ? Hello, yes. So the alteration must not constitute an operation or the fraud on in a minority shareholders, for the to do fraud upon the minority shareholders. So you cannot do such kind of things. There is another case also, Brown versus British Abrasive Wheel Company Limited. So a company was in a financial difficulty. The majority of the shareholders were willing to provide more capital if the remaining shareholders, that is less than about 2%, would sell them their shares. So the majority then passed a special resolution altering the articles of association to enable 98% of shareholders to buy out any other shareholder. The court held that the alteration was not made bona fide for the benefit of the company. So it is an oppression on the minority. Have an example. If I am buying one share in Hindustan Unilever, and you bought, Srinath has bought 100 shares, and Srinath is again the majority a shareholder who having more shares, and I am the minority shareholder. And what exactly company is going to forfeit minority shareholders shares, and they wanted to alter the article of association for forfeiting of shares. So those who having one shares, two shares, or a feeble number of shares, or a trivial number of shares, have to forcefully, they have to give it to the majority shareholders. That is not a bona fide alteration, that is a malified alteration. All right. So this is all about guys, articles of association, articles of association. All right. So I hope you understood about articles of association. So articles of association is not a charter of a company. It's not a charter of a company. Memorandum of association is the charter of a company, and articles of association is the internal document which is used only for internal purpose. So the memorandum and articles of association of a company are to be registered with the registrar of the companies. Both should be registered with the registrar of the companies, and on registration they become public document. So they are open for public inspection in the office of a registrar of a company on payment of the prescribed fee. But memorandum of association, you can download it from a company's website. So every person dealing with the company is presumed to have read the memorandum and the articles of association, and is deemed to have a knowledge to content of these documents. So by this way, there is an exception. By this way, a general public can access article of association of any company. They have to give a request to the registrar of a company, and registrar of a company will go through that, and you are genuine and your request is for a bona fide reason, definitely they will give a copy to you as per your application, and with a prescribed fee, paying of a prescribed fee. So it is not as known as a constructive notice of a memorandum and articles of association. So there is a case called Kolta Venkatasamy versus Ramamurthy. Kolta Venkatasamy versus Ramamurthy. So here in this case, the article of association of a company required that all deeds should be signed by managing director, the secretary, and a working director on behalf of the company. So the plaintiff accepted a deed of a mortgage executed by the secretary and a working director. So the court declared that the mortgage is invalid, because the court held that the plaintiff have had a constructive notice of the content of article. So if you are going to deal with this kind of a dealing, definitely you have to read the memorandum of association and article of association before going for this kind of personal dealings with the company. So in this, the plaintiff cannot claim anything. Plaintiff cannot claim anything, because the plaintiff know that plaintiff should have to ignorantia juris non excuse act, because the plaintiff, before dealing with the plaintiff, means the person who giving the complaint. And what exactly he did, the deed should be signed by managing director and the secretary and a working director on behalf of the company. The plaintiff accepted a deed of mortgage executed by secretary and a working director, but the managing director failed to sign that particular mortgage. So ignorantia juris non excuse act, ignorance of a law is not an excuse. The plaintiff should know about those things. The plaintiff should have to read the memorandum of association and article of association, so that he knows the powers who can do all this kind of a signing of deeds and all. So he cannot say that at the end of the day he cannot say that I'm not aware about those things. So court will consider that the plaintiff was aware about those things, because it is his honors to know that all who is responsible for signing a deed or anything. Then only because company is act uh, um, the company's hands and legs are managing director. So his sign is mandatory for every deeds or agreement of memorandum of understanding, everything. So the court declared it as a the mortgage is invalid. So in Rajendra Nath Datta versus Shibendra Nath Mukherjee, in this case the court held that the articles of association of a company is a public document where it, they they can access through the registrar of the company. Okay, they can access it through registrar of the company and by operation of the doctrine of constructive notice. So every person dealing with the company is presumed to have the knowledge of content of a memorandum and article of association, and later they cannot deny that I'm not aware about those things. Understood? So the doctrine of constructive notice operates. That means constructive notice means if a company is forming, there is always a notice that we have an article of association and memorandum of association. If you want to read, go there to the website and download the memorandum, or go to the registrar of companies and apply and read and deal with us. So it is called as a doctrine of constructive notice. I hope you understood about articles of association. Okay, let me